We appreciate deeply the work of the Federal Society to Preserve Freedom and the Separation of Governmental Powers, and its work to promote the view that it is the province and duty of the judiciary to say what the law is, not what it should be. We're also very, very pleased to have Clark Neily with us this evening. Thank you very much for traveling up. It's great to see you. Clark joined the Institute for Justice as a senior attorney in 2000. He litigates economic liberty, property rights, free speech, and school choice cases at both the federal and the state level. He helped create the Institute's Center for Judicial Engagement, which was designed to challenge the unconstitutional expansion of government by articulating a principled vision of judicial review, educating the public about the importance of a properly engaged judiciary, which is really the topic of this evening's conversation, and advocating the Constitution as a charter of liberty and a bulwark against illegitimate assumption of government power. Before joining IJ, he spent 4 years as a litigator at the Dallas-based firm Thompson & Knight. He received his undergraduate and law degrees from the University of Texas. His book, Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government, is a great read. I had the pleasure the last couple of nights of spending long hours with it. Actually, not long hours. No, it's truly a great read. It's a breezy read in the sense that he articulates in language that even someone like myself, who's not a lawyer, can understand. And it's good news that after our conversation in the Q&A period, there are books over here. If you want to pick up a book and have it signed by Clark, you can do that. It includes what I found really interesting discussions of the court's selective emphasis of privileged rights. There's a real picking and choosing going on here. There are also insights as to why judges in the Supreme Court have so easily abdicated their role. And I think what was really exciting to me for you who do not know about Institute for Justice, mixed in throughout the book, is a series of examples of where IJ goes to bat for the little people and articulates this in practice, in litigation. So I hope you learn more about IJ tonight. I hope you learn more about the Constitution tonight, and I thank you very much for being here, Clark.
Thank you so much for that gracious introduction. I want to thank the Pioneer Institute and the Federal Society for having me up. It's really a pleasure to be here. Though I was born in Texas and went to school for most of my life there, I actually spent about 8 years of my childhood going to school outside of Boston in Lincoln. And my dad and my stepmom are here with me, so there's actually 2 Clark Neilys in the room. And so it's just incredibly gratifying to be here with all of you and back in Boston, which was at one time the cradle of liberty. And I'm really looking forward to your questions. I'll speak for maybe 20 or 25 minutes to sort of articulate the thesis of the book and tell you a couple of stories. And then I'd really like to hear your questions. So we'll certainly get to that. We'll have plenty of time to hopefully have an interesting exchange. I've been litigating public interest cases, constitutional cases at the Institute for Justice, which is the nation's premier libertarian public interest law firm, for 14 years now. I joined IJ in the spring of 2000. I've litigated everything that we do: school choice, property rights, economic liberty, and free speech. And somewhere along the way, it sort of began to dawn on me that, that in some constitutional cases, you get one kind of judging, which in the book I refer to as real judging, or judicial engagement, to use the term coined by Institute for Justice President Chip Miller. And in other cases, you get something quite different, which I finally just came out and said in the book, is fake judging, make-believe judging. It is not different standards of review. Those of you who've been to law school and remember your constitutional law class, you're probably taught that there are essentially 3 levels of judicial review. There's strict scrutiny for rights that courts really care about. There has to be a compelling government interest. The law has to be narrowly tailored to advancing that interest. And then you were probably taught that there's intermediate scrutiny for rights that are not quite as important, but still kind of important. The government interest has to be important, not compelling, and there has to be at least some relationship between the regulation and the government's concern. And then you were probably taught that there's this 3rd level of scrutiny called rational basis review, where basically any conceivable set of facts will support the challenged law. The problem for me with that framework is that it's not wrong, but it's not very informative. It's not as precise as it should be. There's really only two standards of review. There's real judging and fake judging. And I'm going to articulate and explain what I mean by that in a moment. But the reason I preface the talk that way is because what dawned on me as I was litigating that essentially this might be the answer to a question that I think a lot of my conservative and libertarian friends ask, and a lot of people who are not even particularly involved in public policy ask, and that is, how is it that we have a constitution, in my view, perhaps the greatest secular document ever written, that provides for about this much government, but what we have in real life is an amount of government that I can't illustrate because my arms don't stretch, right? And it's a very fundamental question. Why did the framers go to so much trouble to create a government of enumerated and therefore limited powers? Why has the Constitution been amended to further restrict the powers of government, including particularly the 14th Amendment, which was added to the Constitution in the wake of the Civil War in 1868? Why did they go to all this trouble to limit the size and scope of government, and yet we have so much of it? And after a lot of thinking, a lot of not just thinking, but participating actively in the creation of constitutional precedent, some of it awful, sorry, but some of it good, it really did finally begin to dawn on me that there are two distinctly different kinds of judging in constitutional cases, real and fake. And what I'm going to try and sort of articulate and hope to persuade you of in the next 15 or 20 minutes is that that's true, it's wrong, that's not just wrong, it's horrifying, and there's a better way to do it. So one of the, I would say, sort of galvanizing moments for me as a public interest lawyer was the Kelo v. City of New London case. Probably most of you have heard of that case. It involved the question of whether there are any limits on the government's use of eminent domain to take property forcibly from one private party and give it to another who proposes to do something else with it. The Supreme Court basically said no, there are no meaningful limits on the government's use of eminent domain to effect basically compelled transfers of property between private owners. I didn't argue the case, my colleague Scott Bullock argued it, but I was on the trial team and got to participate in the trial a bit and the run-up to the litigation run up to trial. And I'm good friends with Suzette Kelo, I'm good friends with the other plaintiffs in that case. I had dinner on their porches that were subsequently bulldozed, and they unburdened themselves to me. So I will let you know, I don't think this is going to come as a surprise to anybody. I'm a partisan when it comes to some of the stories that I'm about to tell you, but I was there. And I'll spare you the nitty-gritty details of the Kelo case. For those who don't know, essentially what that case came down to was, can the City of New London take all of the property in a working-class neighborhood, bulldoze it, scrape it flat, and then deliver all of that property, it's about 99 acres, and deliver all of that property to a private property developer to build Yuppieville for Pfizer? That's essentially what was proposed. High-end housing and a four-star hotel, that's what they wanted. And we fought that case up through the Connecticut state court system. Then we got to the US Supreme Court, and it really did come down to that. That was the distilled essence of that case. Can a local government invoke the power, exercise the power of eminent domain to take property from a bunch of working class citizens who have working class homes and businesses and take it away from them, give that property to a wealthy property developer on the premise that maybe the Yuppieville that might then be built will raise the tax base, perhaps create some jobs. Let me jump to the end of the story, or I don't know if it's the end of the story, but where the story is right now. This Yuppieville was never built. It is city of the neighborhood of Fort Trumbull, which is the area in question. Neighborhood of Fort Trumbull is now a 99-acre brownfield. It has been scraped clean, but nothing has been built. They keep having ideas. The projects keep falling apart. The developer pulled out. Pfizer moved away. The only jobs that were ever created by that project were the jobs of the bulldozer operators who leveled the neighborhood, and that's it. So that to me is the face of eminent domain. But here's the point about the case that I really want to get across. When Kelo came down, there were two vastly different reactions to it. Ordinary people, or at least most of the ordinary people that I saw, and certainly polling data supports this, were shocked by the decision. They were outraged by the decision. They were horrified at the idea that the only thing that stands between them and losing their home or business is basically who can work the levers of power with a local government, a local city council like the London City Council or even a state government. And that essentially if you're not putting your property to its highest economic use, it can be taken from you by anybody who A, proposes to put it to a higher use, and B, has access to political power or more access than you do. And that's pretty scary. So on one hand, you had this very shocked and outraged reaction by what I would call just sort of average people. But on the other hand, among kind of professional constitutional law people, I'm talking about professors, judges, public policy people, Kelo was actually greeted with a collective yawn. Most of those people believed that Kelo represented nothing more than the routine application of precedent to a new set of facts that just happened not to have been litigated yet. And frankly, that's not inaccurate. The Supreme Court threw property rights off the back of the constitutional sled in the 1930s during the New Deal era. And the only thing that hadn't happened yet is this particular fact pattern hadn't gotten up to the Supreme Court yet. But it had gotten up to state Supreme Courts, most famously in the Poletown case in Detroit, Michigan, where the city decided they would just bulldoze an entire ethnic neighborhood of Polish people, not surprisingly, and just give the land to GM to build a new plant. That project also fell apart. Eminent domain does not have a very strong track record in terms of being an effective public policy, in addition to being a glaring constitutional violation. But this made me pause. This made me pause and think, why is it the constitutional elites found nothing troubling about the Kelo decision, and the average person really did? And that, I think, is very interesting. And what I think, again, it comes down to, and what I try to articulate in the book, is people in the know understand that the Supreme Court has not been making an effort to enforce many different kinds of constitutional limits for 75 or 80 years. It makes no serious effort to enforce the doctrine of federalism, the idea that the federal government has only enumerated and therefore limited powers. It doesn't make any serious effort, as we know from the Obamacare decision, which came down in June of 2012. They don't make any effort to enforce constitutional limits on government power in the area of property rights or economic liberty or tax policy. I mean, the list just goes on and on. And what struck me is that there was a real opportunity here to make an argument, which is the argument that I make in the book, that no matter what you personally believe about the Constitution and what it means, that maybe we can all agree, and when I say all of us, not just all of us in this room, but everybody, every person of good faith, no matter whether they consider themselves to be a liberal, progressive, libertarian, conservative, that maybe we can all agree that no matter what we think the Constitution means, we shouldn't have fake judging. We shouldn't have judges just going through the motions and pretending to judge while doing no such thing. And I want to articulate that. I have a prop here. I've gotten into coconut water recently. Does anybody know what I like coconut water? It's like nature's Gatorade. I like it. It also makes a good prop. So I'm going to give you about a 3-minute sort of a mini seminar on constitutional law. And really, this is all you really need to know about constitutional law to understand the point that I'm making here in the book. Imagine two different kinds of laws about coconut water. One law forbids you from advertising coconut water. You still sell it, you can't advertise it. The other law forbids you from selling it at all. Now, as constitutional lawyers know, you will get two different standards of review depending which law is being challenged. So we challenge the advertising ban. You get what is broadly referred to as intermediate scrutiny or heightened scrutiny. Specifically, it is the central Hudson test for commercial speech. You are advertising a product, that, according to the Supreme Court, makes it commercial speech. And so you get a somewhat lower standard than most speech gets. You get intermediate scrutiny. But if it's the sales ban, you get something called rational basis review that I referred to a moment ago. All right, what's the difference? The difference is everything. Okay, so I've actually done commercial speech cases before. I'm very familiar with how it works in real life, and here's how it works. The burden, if you go into court challenging an advertising restriction or some other commercial speech restriction, the government bears the burden on every important point. In other words, the government will have to articulate a genuine, not fake, not hypothetical, but a genuine concern. So they say, for example, this stuff is deadly poison, okay? Then you have to prove it. So you have to articulate the concern, deadly poison. Then the government has the burden of producing evidence to support its assertion that this is deadly poison. And if the government doesn't have any evidence to support that assertion, then the regulation will be struck down. There's one more element to the central Hudson test for commercial speech, is that in addition to articulating a genuine interest, not a hypothetical one or a made-up one, but a genuine one, and in addition to having some evidence to support that, there also has to be a reasonable relationship between the regulation that the government has chosen and the concern that they have. So in other words, the court is going to say, for example, could you not have done a warning statement? You know, like on cigarette packs or something like that. Could you not have essentially required the coconut water manufacturers to advise people of what it is about the coconut water that is so deadly according to you? And why didn't you do that? And the government will have to have a pretty good answer for that, why that wouldn't have worked, or why coconut water is so much different than cigarettes that wouldn't work, or alcohol, and so forth and so on. And again, the government bears the burden every step along the way. So they have to have a genuine reason, they have to have real evidence, and there has to be they have to show that they've exercised some measure of care in coming up with this restriction. Okay. Go over to the sales restriction, and this is sort of interesting, right? Because here all they were doing was interfering with your ability to advertise a product. You can still sell it. Now it's a complete ban on selling the product. They have completely interfered or restricted the livelihoods of people who want to sell this product. But believe it or not, now you actually get a more government-friendly standard review. It should really be the opposite if you think about it, but note it's more government-friendly because the Supreme Court considers commercial activity to be a much less important right than commercial speech. And that, I saw it, that's an excellent, I get that look in my face too. That's just crazy, but it's true. Here's how the Supreme Court, or any court following Supreme Court precedent, would handle the sales restriction. Instead of having to articulate a genuine explanation for its conduct, the government is allowed, and indeed encouraged, to make things up. It doesn't have to come into court and tell the truth. No, far from it. The government gets to come in and just make things up, and just hypothesize what it might have been doing. Now, we all know that in most cases what it's probably doing is it was acted upon by the influence of the lobbying firms for Snapple and for Coca-Cola and for all these other drinks that are competing, but that's okay. They don't have to admit that that's what happened. They can just make things up, and that's what they do. And they're not even, it's not just that they're encouraged to make things up, they're actually rewarded for making things up, because if they can make up an explanation for why they're limiting the sale of the coconut water, then the law is going to be upheld. They don't have to have any evidence. This has actually been repeatedly stated by the Supreme Court. There doesn't have to be a shred of evidence. They come in and say it's deadly poison. They don't have to present any evidence that that's true. Instead, the burden is on the challenger. This is the Institute for Justice, or me, my colleagues, and other groups that challenge these laws. We have to prove every possible justification that they could offer. We have to disprove it. So in theory, I guess, I have to bring in an expert on who knows what. I have to bring in, nutritionists, and I have to bring in maybe, a volcanologist to say it doesn't have anything to do with keeping the volcano gods happy and all this stuff, I don't even know. I mean, it's really kind of a tough metaphysical question. What does it really mean to negate every conceivable justification for a law? I'm trying to get your head around that one, and that's actual doctrine. I'm not making that up. And then the last bit, well, there's two more bits. One is that there doesn't have to be any particular relationship between the regulation and the stated concern, as there does when it's a heightened scrutiny case. Any rational relation will suffice, and rational in this context basically means anything. And then here's the last bit. This part is absolutely flabbergasting. Believe it or not, if the government lawyers are insufficiently creative to make up justifications for this law, the judge is supposed to get involved, and the judge is required to help the government make up justification for its own conduct. Can you imagine any other setting in which that would be tolerable? I mean, imagine you're a lawyer trying your first case in court, and it's a breach of contract case against the government or an employment discrimination case, and the judge calls you to the bench and he says, hey, counsel, before we get started, I need to let you know that last night I was retained by the government to help them think of justifications for the breach of contract or the alleged employment discrimination. Now, I want to assure you that I'm not going to get involved in this case unless necessary to help the government win, and I will limit myself to just helping them invent defenses to your case. The judge says, okay, step back. Are we ready to proceed? Well, not if you don't want to get disbarred. Because your client has a right, at least in every setting outside of a rational basis constitutional case, your client has an absolute right to a neutral adjudicator. But in rational basis cases, they don't get one, because the judge will come into the courtroom wearing the uniform of an umpire, to use John Roberts' memorable imagery. The judge will come in wearing the uniform of an umpire, but make no mistake, under that uniform, he will be wearing the uniform of the other team, namely the government. He is sitting in that courtroom, or she, charged by the Supreme Court with helping the government win that case. That's nuts. And that's an example of, I think, where we have a really amazing opportunity to challenge the existing doctrine that says to judges, in most cases, you should do nothing. You should do nothing to protect liberty. You should do nothing to protect or to limit government. And the way you do that nothing is you sit up there and you pretend to be a judge, but you actually play for the other side. You play for the government and help them win. I don't think anybody can defend that. And in fact, I've been doing this for a couple of years at events like this, debating law professors, commenting in settings where judges were present. I've never had anybody try to defend the current system. And that's pretty staggering, because this really is how it works. I'm not making this up. This is how it works, and it's indefensible. So maybe that's the good news. It's horrifying that it is this way, but it's indefensible. And so I feel like if you just get the word out, then maybe that's enough to change it. All right, let me tell you a few stories to illustrate just how bad things have gotten, how utterly unwilling and uninterested courts are in enforcing limits on government power. some of you may remember that one of the things we were supposed to take some comfort in when the Supreme Court upheld the Affordable Care Act, or I should say what used to be the individual mandate, although apparently now it's the individual option, was that 5 justices refused to go along with the government's usual defense whenever it usurps, or the federal government's usual defense when it usurps power, which is to just say, oh, we're just regulating interstate commerce, the Commerce Clause. You've heard it before, that's what they do. In the book I call it old reliable, because for 75 years it's been reliable. There's only 2 cases in 75 years where the Supreme Court has held that the federal government didn't have the power to do something under the Commerce Clause. Well, now 3, now that we have Obamacare. But as most of you probably know, Chief Justice Roberts voted with the other, the 4 liberal justices to say, oh, well, it's not an exercise, or it's not a valid exercise of the commerce power, but it's a valid exercise of the tax power. And that was ludicrous. He's maybe the most persuasive human being born in America in the last 50 or 60 years, and that's the single most unpersuasive judicial opinion I've ever read. It's ludicrous. Put that aside. We were supposed to take comfort in the idea that 5 justices had said, no, not going to go along with the exercise of commerce power here. Well, guess what? The lower courts apparently didn't get the memo, because the very same court, the only federal court of appeals that voted to strike down Obamacare was the 11th U.S. Circuit Court of Appeals. Covers Florida, Georgia, and Mississippi. I'm sorry, Alabama. And a case came up out of Florida 5 months later through the 11th Circuit, after the Supreme Court had supposedly put down this marker on commerce power. And the fact pattern is wonderful. You can't invent stuff this amusing. There is a museum in Key West. Anybody been to Key West, Florida? There's a museum in Key West called the Hemingway Home and Museum. It's Hemingway's old house where he used to write he did a lot of his great writing. And one of the things you notice about this museum when you go there is there's a lot of cats wandering around. These are the descendants of a cat that was supposedly given to Hemingway by a sea captain. The cat's name was Snowball, and it had 6 toes, all of which sounds almost too perfect to be true, and I understand there's some controversy about whether it really went down that way. But there's definitely a bunch of cats wandering around this museum. And my wife and I were there in February, so I've seen it with my own 2 eyes. What happened was that the museum somehow got crosswise with a volunteer, and she wanted to get the museum in trouble. And she decided the way she would do that would be that she would report to the relevant authorities that the cats at the museum had no shelters to sleep under. They were sleeping under the stars every night, which, as I understand it, cats have been doing for some time, but put that aside. Put that aside for the moment. Now here's the question: who do you go to if you want to get, who are the relevant authorities if you want to get the hotel in trouble for not having adequate cat accommodations? And you might think, the local animal controller or the county health board or something like that, but no, she really swung for the fences. She actually went all the way to the U.S. Department of Agriculture and dropped the dime on the museum to the U.S. Department of Agriculture. And believe it or not, there actually is a federal law that was put on the books, I think in the mid-60s, that empowers or purports to empower the Department of Agriculture to regulate exhibitors of animals. Now, this was supposed to be like circus elephants that are being abused and taken from one state to the other, so it's very difficult for any one state to protect them. But, the federal government and bureaucrats being what they are, the Department of Agriculture has stretched this law rather significantly and decided that the museum, the Hemingway Museum, was in fact an exhibitor of animals and therefore within the jurisdiction of the Department of Agriculture. And they opened a 2-year investigation during which they sent 3 different teams of investigators to document what no one disputed, which is that the cats don't have houses. Somewhat doubt that if it had been in Minnesota or somewhere like that, it would have taken 3 trips, but Key West, go figure. And after documenting that the cats did not have shelters to sleep under, they sat down with the owners of the museum and began to dictate to them how they were going to bring their cat accommodations up to par. The museum sued, good for them, and made 2, I think, very strong arguments. One is you are misinterpreting the statute. We are not exhibitors of animals, and so statutorily we don't fall within your purview. And second, you have no constitutional authority. You're the federal government. You're the federal. You only have those powers listed in Article 1, Section 8 of the Constitution, and we are not counterfeiting money, and we are not pirates. And there's no intellectual property issue, so pretty much we're done. Well, the federal government, as it normally does, invoked old reliable, the power to regulate interstate commerce. Now ask her, and the 11th Circuit went along with it. They rubber stamped it like they usually do. Now, how do you get to interstate commerce? You have a bunch of cats that have never been bought or sold, just born, and they are marooned at the very southern tip of Florida. They will never cross the state line. They're marooned on an island at the very southern tip of Florida. They will never cross the state line. But remember, we're not talking about real judging here, we're talking about fake judging. We're talking about the judge working together with the government to try to come up with some way to rubber stamp what the government is doing, which is what judges do in most constitutional cases. And so if you put enough creative people in a room to come up with something, you'll get there, and they did. How'd they do it? Well, There's a gift shop at the museum. Now, I'm not making this up. There's a gift shop at the museum, and they sell cat-related merchandise, pot holders and keychains and that kind of thing. And the idea was, oh, and by the way, it's not just enough that the cats affect interstate commerce. They have to substantially affect interstate commerce. And the 11th Circuit held that they did because maybe people are coming down all the way from here in Boston or Texas, where I'm from. They're coming all the way to buy a cat-themed pot holder at the Hemingway Home Museum. Now, I'm glad that you're laughing at it because it really is, I mean, it's a risible decision. But stop and remember that even though the application of the doctrine in this case is hilarious, what we're talking about here is the most fundamental constitutional principle that exists. I mean, we almost didn't have a constitution because a bunch of people called the Anti-Federalists thought it was unwise to create a federal government that might be able to tyrannize us the way the British had been doing until we fought them off after 8 years of bloody conflict. And they said, you know, maybe that's not such a good idea. And the Federalists said, no, don't worry about it. We have created a federal government of strictly enumerated powers. The federal government only has those powers that the Constitution delegates to it. And that's what's going to protect us. Well, that is the way the system is supposed to work. And the federal judiciary has steadfastly refused to enforce it in that manner for 75 or 80 years because they know better. And that's wrong. All right, a couple more stories and I'd like to hear your questions. The issue that's probably nearest and dearest to my heart is economic liberty, the right to earn a living in the occupation of your choice. I think that's maybe the most fundamental right that any American citizen has. And by the way, the protection of that right for the first 100 or 150 years or so is why we are the most prosperous nation in the world, make no mistake. It's not because we're smarter, it's not because we're more industrious, it's not because we stumbled onto some amazing process. We have great natural resources, but a lot of other countries do too. I was a Russian major. They have a lot of natural resources. But what they don't have is what we did have for 150 years, and that's the rule of law. And specifically the idea that there are things the government cannot do, no matter how wealthy you get, and no matter how innovative your service or product. And that was the law for the first 150 years or so. But then the Supreme Court, very unwisely, decided to jettison that principle to make way for the New Deal, to empower the federal government and later state and local governments to micromanage the economy, to micromanage all economies that exist in the United States, and basically said we are just not going to be in the business of enforcing any sort of meaningful limits on government power. Now, those of you who have any sophistication whatsoever in economics know there's something called public choice theory, and what that essentially provides is that when the government exercises that much power over how people make money and how that money is distributed, there'll be tremendous incentives to, instead of going out and producing, you make money by influencing the levers of power. So if a guy actually goes out and invents a better mousetrap and you happen to be in the mousetrap business, you don't want to sink a bunch of money into R&D because that might not pay off. Instead, you sink a bunch of money into a lobbyist to hamstring your competitor so he can't sell his mousetrap. Yeah, it's better. That's the point. That's why he shouldn't be able to sell it. And you hire a lobbyist to make that the law. That happens every day, day in and day out. So I'll give you an example from a case that I actually litigated in Louisiana. Alone among the states, you have to have a license to be a florist in Louisiana. So just like you have to have a license to be a doctor, lawyer, architect, in Louisiana, if you take two flowers and put them together in an aesthetically appealing way, you're a florist. And it's illegal for you to do that, or it's illegal for you to sell that arrangement without permission from the government. Now, obviously, this law was put on the books at the behest of the Louisiana State Florist Association, which there really is one, and they really swing a lot of political clout down there, but that's who got the law on the books. But because it's a rational basis case, because it's an economic issue, and therefore the judge has to apply rational basis review, there's not going to be any real judging going on in this case. It's all going to be fake judging, like I just described in the Hemingway case. So we challenged the law on behalf of 3 aspiring florists, including our lead plaintiff, a woman named Sandy Meadows. Sandy was a widow and a high school dropout from Mississippi. She lived in Baton Rouge. She had only one vocational skill, and that was making flower arrangements. But she, and I should say, so she was working under the radar, which is a bizarre way to put it, but she was in fact a black market florist because she didn't have a license from the government. But she was actually really good at it. She got hired by an Albertsons grocery store to run their floral department. For those who don't know, the floral department of a grocery store is not where you go to handle your daughter's wedding, where you go when it's midnight and you have an apology to make and words fail you. So she was managing the floral department in Albertsons grocery store when the Louisiana Floral Police, they're actually called the Louisiana Horticulture Commission, I call them the Floral Police because that's what they are, got wind of it. They paid a visit. And they talked to the manager of the grocery store and they said, she doesn't have a license and so she can't run your floral department. In fact, she can't work there. You have to have a state licensed florist working in your floral department. Well, they only needed one. They didn't need two. So they fired her and hired a state licensed florist instead. Sandy tried to pass that test 5 times, but it was too subjective. You got to hand it to Louisiana, by the way. When they go corrupt, they really go all the way. The exam to get a florist license, at the time we sued, they've changed it since then, but the time we sued in 2003 was in 2 parts. You had to take a 50-question true-false test, which usually wasn't a problem for most people, but then you had to do a practical exam. You had to make 4 floral arrangements in 4 hours that would then be graded not by some theoretically disinterested bureaucrat, but by a panel of 6 working florists who would be brought in to judge whether you were good enough to compete with them. Everybody guess what they usually said? Usually you were not. We actually got the data for the 10 years before we filed suit. The pass rate in Louisiana florist exam was 36.5%. Pass rate on Louisiana bar exam, for point of comparison, 61%. Twice as hard to be a florist in Louisiana as a lawyer. So we challenged the law, and unfortunately we got the kind of fake judging that I wrote about in the book, and the judge essentially worked with the government lawyer to invent justifications for the law, which was obviously not a just law. And some of the things he came up with, which are, I have to hand it to him, they are comical, but one of the things that he thought maybe was potential justification for the law was infected dirt, which is puzzling to me because to this day I don't know what the dirt was infected with, and also there's nothing on either of the tests about infected dirt, so it seems to me there's a complete mismatch, but let's not get bogged down in details, because the point of judging in this case is not really to evaluate the constitutionality of the law, is to provide the simulacra of judicial review while rubber stamping whatever the government has done. So we upheld the law. Fortunately, we took it up on appeal, and for better or for worse, Hurricane Katrina came along. I don't know if there's an act of divine retribution or not, probably not. But it mooted the case because all of our plaintiffs had to leave the state. So the good news is that when a case becomes moot while it's on appeal, you can get the lower court decision vacated, which means sort of erased from the book. So we did that. That's good. I'll tell you unfortunately, the sad epilogue to the case. I went down to Baton Rouge in September of 2004 to get Sandy Meadows, my lead plaintiff, ready for her deposition. She was going to be questioned by state lawyers about why she wanted to be a florist. And when I went to her apartment, I found her lying on a couch in the common area of the apartment, being fanned by a friend of hers with a piece of cardboard. It was the most pathetic thing I've ever seen. She had surgical stitches from here to here because she's had gallbladder surgery. And the reason she was lying in the common area was there was no air conditioning in her apartment. Couldn't afford it. After she got fired from the store, she literally couldn't afford electricity. And so I loaded her up in a rental car. I took her to a Piggly Wiggly where you could write a check to get her utilities turned on, which I did. And then I checked her into a La Quinta Motor Inn so she could have at least one night in comfort, the air conditioning. And I told her, listen, we're going to cancel the deposition. Don't worry about it. I'll come back later and we'll deal with it then. That was the last time I saw her alive. She died a couple months later alone in poverty because the state of Louisiana said you have to have a license to be a florist, and a federal judge did nothing to protect her right to earn a living. And so for me, that's the face of judicial abdication. And the opposite of that is judicial engagement. The opposite of that is real judging. And every American deserves real judging in every case. Whether you're trying to get the Department of Agriculture off your back because it's none of their business, what happens to your cats at night, or whether you're Sandy Meadows just trying to earn a living the only way you know how, by selling floral arrangements. That's no business of the government's, and it is definitely not legitimate or valid or appropriate for the judiciary to work together with government to try to justify what the government's doing. And I'm here to tell you that's how it works in most areas of constitutional law. So I'll end with that, is to basically just tell you, here's the bad news. According to the Supreme Court, there are 2 kinds of rights, fundamental and non-fundamental. What they really mean is meaningful and meaningless. Meaningful fundamental rights are the exception. There's only a handful of them, and that's the only time you get a real judge when you go into court. So free speech, some kinds of free exercise cases, racial and to an extent gender discrimination, but basically outside of a small handful of cases you get fake judging because the Supreme Court considers most of your constitutional rights to be non-fundamental, by which they mean meaningless. And so you get rational basis review of the kind I described a moment ago, and that's just fake judging. As I described in the book, rational basis review is just a constitutional shell game in which liberty is the P that disappears at the end. So they've got the game rigged, and you almost always lose, and everybody knows it. And you almost always lose not because you don't have a good case, you lose because you didn't have a real judge. You just had somebody who was there to uphold whatever the government was doing. What do I think we can do with this? Well, I think the good news is that, as I explained in the book, it is indefensible. I give these talks all over the country. No one ever tries to stand up and justify the system. Basically, no one disagrees that this is an accurate description, and no one tries to defend it when pushed to do so. My hope is that what we can do is essentially just get the word out, to be not furious about it, but to have a reasonable level of righteous anger and tell people who are in a position to do something about it that we expect them to do something about it. And I have this sort of intermittent fantasy in which a chairman of the Senate Judiciary Committee, Ted Cruz or Mike Lee or Rand Paul, chairs the next nomination hearing for a Supreme Court nominee and says right at the beginning, I want to tell you something. We're going to start with the question of limited government, and if you don't have a concrete theory of limited government, this is going to be a very short hearing. That's not impossible. That is not at all impossible. And I don't think it is impossible to repopulate the federal judiciary with people who take the Constitution seriously, with people who reject fake judging, and with people who are prepared to discharge the duty that I'm convinced the framers gave to the federal courts, and that is to enforce constitutional limits on government power. The rule of law and the meaningful limits on government power that we had for the first 3/4 of the country's existence are why we have gotten to where we are today. We are coasting in a sense because we have abandoned those principles, or at least the judiciary has largely abandoned those principles, but I don't think they're so far in the rearview mirror that we can't recover them. And the good news is this is not a terribly difficult case to make, as you can see. So, thank you.
You want to come to the microphone? Come on, you can do it.
Hi.
Hi.
How would any of us, if we weren't in Congress, how would any of us have any hope of doing anything to roll this back, especially when I would guess that more than half the country would agree that the system that you described is a good one?
It is a challenge. It is not my experience that more than half the country agrees that what I have just described is a good thing. I give talks in front of community groups, in front of law schools, in front of all different kinds of audiences, and generally speaking, people are pretty horrified by what I have just described. Now, many of them may secretly like the fact that what I have just described produces the results they like in particular cases. There are certainly a lot of people who did like the result in Kelo. But I'm not sure people are prepared to defend the methodology by which we got there, namely fake judging. So what I hope is that essentially just by holding up sort of a mirror to the system and showing people who may not have known that in most constitutional cases you get fake judging, that people will essentially get together and say, well, listen, that's not right, and we're not going to stand for that. As individuals, there's not a whole lot that any one of us can do. But I think what we can do is maybe pull together and say, to a senator who is, for example, open to the idea, look, you're not getting any more support from me, you're not getting any more support from anybody that I know if I don't hear you grilling a nominee about limited government the next time there's a confirmation hearing. I expect to hear that, I insist on hearing of that, and if you don't hear that, you don't need to send me any more of your campaign literature. I think that's not inconceivable. In fact, that's certainly my personal plan. And maybe if we all, those of us who really care about limited government do that with some unity, maybe it can have an effect. I hope so. Yeah.
Clark, nice to see you again. Ben Dexter doing a lot on the street. We love having you when you come by. I read the book, great, love it a lot. And I'm wondering if you would expound upon something you touched upon in the book a little bit. If you were to walk into a group of constitutional law professors or a group of constitutional litigators and say, economic liberty deserves better protection, what you're going to hear is, well, you're doing Lochner, right? You're like, this is a return to Lochner, and Justice Holmes gave his opinion about Mr. Spencer's social statistics, and Peckham was wrong, even though he was the majority opinion, and the guy who gave the concurrence was, well, he shouldn't have concurred, but he kind of had it right. How do you go against that argument that's so ingrained in the constitutional litigator's mindset? How do you take that argument and say, no, that's wrong?
Well, good to see you again, Ben. Thank you. Let me do a little setup for those who don't know. One of the most famous cases for constitutional lawyers in Supreme Court history is a case called Lockerbie New York. And I'll give you the setup really quickly. The setup is this. In the very early 1900s, New York adopted a law that made it illegal to employ a baker for more than 10 hours a day or 60 hours a week in a bakery. And the asserted purpose of the law was that bakeries are unhealthy places to work, and so we don't want people exposed to that environment for too many hours in a day or a week. The counter-narrative, which has gained a lot of traction lately as more competent historians have looked at what really happened, is that basically this was a straight-up fight between large mechanized bakeries and their unionized employees on the one hand, who did not need to put in long hours because they were automated, and immigrant bakers who were coming and fresh off the boat, and the only way they could compete with the established bakery was to put in longer hours. And when you don't have an automated bakery, it turns out that basically what you have to do is you have to put in 2 6 to 8 hour shifts a day. You get the bread ready, then you go to sleep, and then when it comes out of the oven, you're back on the job. And that's how it works. So this was rather obviously, I think, an attempt by established interests to thwart competition from newcomers who just didn't have the capital to automate their own bakeries. And so those were essentially just the two ways of looking at the case. The way the Supreme Court, by a vote of 5-4, voted to strike down the law because they were not convinced that it was genuinely a health measure. They didn't come out and say that New York was engaging in economic protectionism, but they came within a whisker of saying that and struck the law down. Generations of law students have been taught to say Lochner, not that way, but Lochner, with put a lot of stink on the word, because it's the worst, most disgraceful Supreme Court decision in history, and to be confirmed in any kind of a judicial office, you have to be willing to say, yep, I think Lochner was a terrible decision. And the answer, I think, is I just embrace it. I mean, I've long ago sort of let go of any illusions of ever being a judge myself. I'm hoping to inspire future generations. I think Lochner's, perfectly wonderful decision. One of my favorite decisions. It's a courageous decision, and I think we need a judiciary that has the guts to stand up to the other branches and essentially, look, reasonable minds can differ about what was really going on in that case. But if you don't think that that a state government is actually trying to protect people, have the guts to stand up and say it, and just say, you know what, I'm not an infant. I know that sometimes laws get enacted at the behest of the Louisiana Florist Association or the unionized bakers or whatever it might be, and I'm pretty sure that's what's going on here. Now, don't get me wrong, if you actually have some evidence to support the concerns that you've articulated about people getting sick from, being exposed to flour in bakeries or infected dirt or corsage pins or whatever it might be, I'm very happy to consider that evidence. And okay, so you can see that I do this with a little bit of humor. I mean, I try to essentially point out that when somebody comes into court and tries to defend a law that is so important, that it's protecting all these people from these terrible consequences that you don't have a shred of evidence to support, at least the existence of these consequences, then I feel fine kind of gently ridiculing you. Because I'm a litigator. I actually have to bring evidence into court. I mean, I'm a non-government litigator, so I actually have to bring evidence into court to support my factual assertions, and I just don't feel like, that's an undue burden for all lawyers who are asking a court to adopt a particular position that is based on a factual assertion. I don't think it's unreasonable to ask them to bring some evidence. That's all that's really going on in Lochner, as far as I'm concerned. And if you don't have any evidence to support your position, then I don't think you should expect the courts to make it up for you. Not a very popular position within academia, but we are working to change that, aren't we?